I'm the Executive Director for the Center for Transnational Business here at USC Gould School of Law. And together with our partners, the University of Toronto Faculty of Law's Future of Law Lab, we're very pleased to present today's program focusing on the newly proposed amendments to Canada's Competition Act. We have a group of very esteemed panelists joining us today, and to get us started, I'd like to introduce our two co-moderators, Danny Sokol from the USC Gould School of Law and Anthony Niblett from the University of Toronto Faculty of Law. Anthony and Danny.
Well, thanks very much, Brian. As Brian says, my name is Anthony Niblett. I am a professor of law. I'm also the academic advisor at the Future of Law Lab at the University of Toronto, a platform for students, academics, lawyers, and other professionals to come together and participate in collaborative initiatives relating to technology, law, innovation, entrepreneurship. Today, we're talking about the good, the bad, the ugly of the proposed amendments to the Competition Act here in Canada. We've got three outstanding panelists. We've got from practice and from academia. We've got Jason Gudofsky from McCarthy Tétrault. We've got Susan Hutton from Strikeman Elliot. And we've got Ed Iacobucci from the University of Toronto. Susan, if I can just start with you. I was wondering if you could talk us through the process by which the government has introduced these new amendments.
Thank you very much, Anthony and Danny for inviting me. Okay, so the Competition Act amendments are the first significant amendments in over a decade, and they were included in a sort of an omnibus legislation, the Budget Implementation Act. Bill C-19. This was introduced in the House of Commons on April the 28th, and it's likely to pass and be signed into law before the end of June. So this is very fast. It's significant it was included in the budget bill in particular. That's a mammoth piece of legislation, and Competition Act amendments have absolutely nothing to do with the federal budget. And there's a number of amendments to other statutes that are sort of included in there. And the reason it's important is because we follow British parliamentary procedure, which means if there's a vote of confidence, then if the legislation doesn't pass, the government falls and we have to have an election. So budget bills pass. They don't often get debated very much, and there isn't a detailed study at the committee stage. They just get passed. And we've had 3 days of hearings in early May by the House Standing Committee on Finance. They heard only from government witnesses, federal civil servants, from a variety of departments because the bill addresses so many areas. There was a total of about 6 hours of hearings. And there really wasn't any debate. There had been a lot of discussion in Canada leading up to this about the need. Various people had called for amendments to the Competition Act. There was healthy debate coming. A lot of submissions had been made to Senator Whetstone, who had issued a call for public commentary, but the government had never said, oh, we've heard you, this is what we propose to do. And very importantly, they had not, to my knowledge, maybe they did some quiet private consultations, but to my knowledge, they had not run the language they proposed to use by people. And I think, as you'll hear from the panel today, maybe it could have benefited from having a variety of people look at the proposed language. So all signs are, it was reported yesterday out to committee at the Senate stage. First, it has to pass the House of Commons, then the Senate, then it gets signed into law. And the Senate passed some motions that will speed up the committee report stage. So all the signs are that it'll probably be passed into law before July when the House rises for the summer. It's possible it doesn't just die if it's a piece of unfinished business, but being a budget bill, you kind of expect it'll pass.
Susan, thank you so much for that background. I guess the other thing that emerges from what you're saying is that this is not the typical way that competition, I mean, it's been a while, but this is typically not the way that competition legislation has been introduced. There's something different here. And I think maybe the next thing we'll do, Jason, if you could maybe highlight at a broad level the proposed amendment. Some people, of course, are intimately familiar with what's going on, other people less so.
Sure, happy to do that, Danny.
Could you also move the view so that we don't see the preview slides?
Yeah, I am trying to see where this slide shows. Sorry.
Should be bottom right-hand corner.
No, I had it before, so I will, there we
Go
go.
to resume slideshow, yeah.
You have that now?
Now, if you go
Yeah.
to the, well, you know what? This is fine as well. People now know that, that we can preview the next set of slides, and we know that you've got a lot. So I think people can see it large enough on their screens. Why don't you just
Yeah, let's move on. So first of all, Danny, I'd like to thank you and U of T for including me in this panel. Just say that the comments today are my own, are not necessarily the views of our firm or of our clients. And this is not intended to be legal advice, but just to give you my views. And I will say, I think Susan was being awfully polite to say that maybe it would have benefited from some feedback. It absolutely would have benefited from some feedback, and we're going to get into that. But today I've been asked to, within a time frame of 5 to 7 minutes, to go through the amendments. So what I'm going to do is I'm going to go through some of the key amendments that we wanted to highlight today, which we're then going to unpack for you a little bit later on in the presentation. And I'm not planning on going through every slide. It's a large deck, but if you're interested in having a copy of the slides, then please do reach out to the conference organizers. So the first area we wanted to talk about is abuse of dominance. And the way I'm going to do this is I'm going to talk a little bit about what is the framework today, and then what do some of the amendments look like. So first of all, abuse of dominance is covered in the civil provisions of our Competition Act. Our Competition Act largely is split between criminal and civil. So it's in the civil provision, section 79, and the elements are you have to, a person alone or jointly has to have market power, effectively in a relevant market. The person has to be engaged in a practice of anti-competitive acts, which we'll get into in a little bit. And that practice is having, or is likely to have, substantial lessening or prevention of competition. Only the commissioner can bring a challenge under section 79 today, and that's in front of the competition tribunal. And the tribunal has broad remedial powers, including the ability to order an administrative monetary penalty. So one set of amendments that we've seen is, first of all, to broaden the definition of an anti-competitive act. Anti-competitive act is defined in section 78. And so far it's been interpreted by the tribunal to be any conduct that's intended to have a predatory, exclusionary, or disciplinary negative effect on a competitor. So now they're putting that and codifying it in the statute, and then they're trying to expand it by saying, or otherwise has an adverse effect on competition. Second, they've added some additional assessment factors. Those assessment factors, which I'll get into a little bit later on, are going to be carried out through the abuse of dominance, the mergers, and the civil competitor collaboration provisions. They're now going to have private rights of access. We'll get into what that means later on, but just so you know, that's going to be injunctive relief, also on the merits, and the ability to register consent agreements. And then finally, they're going to increase the size of the possible administrative monetary penalties, and they're going to be substantial. And we're going to get into what those are. But in theory, they'll be able to capture worldwide revenues. Although I think this would be an example where they may have screwed up some of the language. So in the next slides, we're going to go to criminalization of certain buy-side agreements between employers. So in
Jason, we're not
2009,
seeing a change in the slides beyond the cover. So if you have to click down on particular slides.
That's weird because it is on my screen. Have I totally screwed this up here, I guess?
Yeah, they're not changing. All we can see is the title page, Jason. So maybe if they're not working for you.
Yeah, we can.
It's okay because we will email the slides to everyone who has signed up. So this is, the ultimate teaser. Imagine that this is literally your blockbuster trailer for a movie. You're like, oh, I'd like to know more. We have more, and Jason has sent us the slides, and we will send it to everyone afterwards. So
all right, I'm taking the slides off. I'm just going through this. So the next
unplug.
The next area is criminalization of certain buy-side agreements. So what has happened is in 2009, the act was amended to provide for per se offenses. And prior to 2009, both buy side and sell side were covered. But in 2009, to allow for buying groups, they removed the purchase side and just now have per se offenses for agreements between competitors that deal with the production or supply of products. Well, when you're dealing with employees, you're talking about the acquisition of services, and therefore they were not covered under the per se criminal conspiracy provisions, but only under our civil competitor collaboration provisions in section 90.1. So that means that to bring a case involving agreements between employers, they would have to establish a substantial lessening of competition, and also only the commissioner would be able to bring those cases forward. So one of the key amendments is that now they're going to have a per se offense for agreements between competitors related to the production or supply of products, that are related to the terms of and conditions of employment or on salary and wages, and also around no poaching of one another's employees. And this is going to be per se illegal. And they've also expanded the potential penalties or fines that can be applied, such that it'll no longer be a cap on the monetary penalties. Note that there'll be a 1-year period for this to come into effect. The next area we wanted to talk about is in the civil competitor collaboration provisions, which I've already noted that there is both agreements between competitors can be dealt with criminally or civilly. Where they dealt with civilly, they're under a substantial lessening of competition standard, and the government is proposing a set of assessment factors through mergers, civil competitor collaborations, and abuse of dominance that are going to look at a conduct where it's going to have network effects, where it entrenches a leading incumbent's market position, or any conduct that has price or non-price effects, including on quality choice of products or on consumer privacy. So they're expanding the assessment factors, clearly intended to capture the gig economy, the digital economy. And so that was another area that we were highlighting for you. Two last areas, one on information gathering. So under our Competition Act, the Bureau, the commissioner can apply to a court for investigations when the commissioner's on inquiry for pretty broad information. They could require somebody attend in person under oath for examination. They could require production of records or documents, or they can require written returns under solemn oath or affirmation. Now, today, if the person who is that orders against is they want information about their affiliates, they can only, first of all, they can only establish getting an order where they can establish that the affiliate has relevant records, and also they can only seek the production of records and documents. So this will be expanded to provide that the commissioner only has to establish where the affiliate is likely to have information, and also to require written returns under oath and solemn affirmation. And finally, it's going to also be expanded to say that the commissioner can seek to compel evidence from persons located outside of Canada who carry on a business in Canada or sell products into Canada. So the last area to highlight, one is mergers. I won't say anything other than on mergers. The assessment factors I went through before in civil competitor collaborations will also be brought into assessment factors for mergers. But the area that I did want to talk quickly about is on notification. So transactions that meet certain thresholds have to be notified in Canada. There's only certain classes of transactions that have to be notified, and there are very strict rules as to whether or not that you have a particular class of transaction and whether the thresholds are exceeded. So the Bureau or the government has decided that they want an anti-avoidance provision. So now where you've designed your transaction to avoid a filing, the Part 9, the filing rules will apply. And the other last change, and one I think is really problematic, is there's a provision that allows in an equity deal for the purchaser to put in a filing where effectively they don't have the cooperation of the target. And now they're limiting that to only cases where it's in part of an unsolicited or hostile takeover bid. And so that's going to be a limiting factor to that provision. And we're going to unpack that a little bit later. So those are the amendments. And I think now we're going to go into looking at each one in more depth.
Fantastic. Thanks very much, Jason, for that excellent overview. So as you say, let's go into each of these proposed amendments in a bit more depth. And I think one of the most controversial ones is this criminalization of wage fixing and no poaching agreements. And Ed, if I can turn to you, good, bad, ugly on the criminalization of these side agreements?
I think good, but actually I think good, but could have been better on this one. So actually, I just want to just briefly, Jason touched on this, but and I actually asked Susan touched on something that I want to go over, which was how we got to where we did with these particular amendments. So Canadian conspiracy law prior to 2009 was not a per se offense. Price fixing had to lessen competition unduly. This created various headaches in the case law, including cases where there were clear price fixing conspiracies, but courts finding, well, this wasn't undue lessening of competition. This is a lessening, not an undue one. There were other issues as well. So there was kind of, I think, dissatisfaction with where we were. There was a sense that we should move towards more of a per se approach. And then in 2009, the amendments were introduced again through a budget bill, which I think is important because as part of those amendments, they made it a per se offense, but they took away the buy-side agreements entirely. So buy-side agreements had been in, they were taken out in 2009. I think this is an example of how broader consultation can be of benefit, because I'm not sure that the idea of a wage fixing agreement being excluded from the Act was an intentional or at least appreciated consequence of those particular amendments. And it would have been, I think, better to subject it to a broader kind of scrutiny than was done before it was put into a budget act. And then, as Susan has rightly described, it becomes a bit of a fait accompli that it's going to pass. So because of that, exclusion of buy-side agreements, there have been some, recent celebrated discussions around what has happened in various industries, and particularly the grocery industry during the pandemic. Major grocery retailers in Canada agreed to, well, I don't know if they agreed with one another. That's a contestable question, but they certainly all increased pay for sort of frontline workers in the pandemic, and then almost simultaneously withdrew that kind of premium as the kind of seriousness of the pandemic receded slightly. And so there was a question whether this was a kind of unlawful conspiracy. The commissioner put out a press release saying that Commissioner of Competition put out a press release saying this may be an agreement, but it's actually not covered by the Act because it only covers sell-side conspiracies, not buy-side. And so we can't do anything about this under our current criminal provisions. So it was a kind of, I think, call for change by the commissioner using this as a particular example. The commissioner could have taken this through a civil provision, which I think Jason alluded to. There would have been a possibility of going to a civil provision for agreements. That I think the challenge for that is there's twofold. One is there's no financial penalty associated with that, so it's a cease and desist order. And I'm not really sure what you do with a cease and desist order if there were indeed a one-time agreement to eliminate a premium. I'm not sure how we would cease and desist at that point because the agreement is essentially done once you've lowered the wages back to their pre-pandemic levels. Okay, so that all said, I think that we have this amendment is actually a good one. I think it could be better, but I think the idea that wage side conspiracies ought not to, wage fixing conspiracies ought not to be covered is not a particularly strong argument. There is controversy in Canada about this. Some have pushed back. The commissioner, a former commissioner, just put out an editorial op-ed piece saying that, well, sometimes wage fixing could be good for consumers. I guess implicitly keeping costs low. Well, that may or may not be true, but I'm not sure why we would accept economic distortions in the labor market as long as they translate into a benefit for consumers, right? It's the distortions that we ought to be going after. And so it's peculiar, I think, a little bit from an equity perspective to say it's okay if workers are getting hurt as long as consumers are benefiting. But I think it's more fundamentally, I think it's problematic from an economic perspective. If these are creating distortions, they ought to be addressed. But that said, I think it could be better. Consultation, I think, would have been helpful. The specifics of the provisions speak about employers They speak about employees, conditions of employment, wages, et cetera. Well, employee is probably never been the distinction between employee and other kinds of workers is not always obvious. I think it's becoming even less obvious as the gig economy emerges even more importantly in recent years. And so I think there's going to be some definitional challenges associated with the application of this provision. And then there's a normative question about, okay, well, why would we want to permit conspiracies about terms of employment, but not conspiracies about terms of engagement with workers who aren't necessarily employees? So that's sort of a peculiar, I think, drafting. The other thing I would say, just as a final comment, it also forbids no poach agreements, which I think is actually a good idea. I think it's important, and sometimes I find the discussion around this kind of elides the two. I think it's important to distinguish between no poach agreements between, which is kind of conspiracy between employers, and non-compete agreements entered into between an employee and an employer. There have been moves at the, Ontario recently banned non-compete agreements. I think a kind of a blanket, at least for employees, I think that kind of blanket ban may be problematic. This could be a sensible term of a contract between an employer and employee. But I do think the no poaching agreements are problematic because they are kind of changing the opportunity set for employees without their consent. It's not something that's bargained over. It's just something that is conspired about between employers. So I think the changes are welcome. I think they could have been better refined and would have benefited from more consultation. And I'll stop there.
Great, thank you. Susan, if I can turn to you, your thoughts on the criminalization?
I largely agree with Ed. I think to the extent that the last round of rushed amendments that didn't get consulted on the language had unintended consequences, then reintroducing wage fixing and no poach agreements in the criminal side makes some sense. I would point out they're still subject to the ancillary and necessary defense. So if the Crown has proved its case, then if the defense can prove that this agreement was ancillary to a different or broader agreement and are necessary to the operation of that not criminal agreement, and one can imagine that therefore this would mean the government won't go after the very commonplace no poach provisions that are included in merger agreements. You've just bought a business and you don't want the seller poaching back all of your employees and making your business non-viable. So it's a very common part. I think that the ancillary and necessary defense will take care of that. But definitely the language could have been improved. Why? And especially in Canada, as payroll taxes increase and the bells and whistles and the hoops employers have to jump through increase, it's absolutely becoming much more common for people to say, no, you're employers to say, you're an independent contractor, you pay your own taxes, you do your own thing. I don't have to pay all this stuff for you that I have to pay for actual employees. And the federal government is hugely guilty of this. So are all the provincial governments. So using the term employee to protect workers when you yourself are hiring thousands and thousands of contractors, to me, that's a problem. And
Jason, your thoughts on criminalization?
Yeah, so, and I'm happy Susan mentioned the ARD because the incident restraints defense, because that's an important point that we're not going to see a problem from mergers and people having those agreements as part of merger agreements. The only thing I would say is, look, I think that this will make us all feel good, and for that reason, because I don't see it other than the argument that the former commissioner made, I don't see a real positive benefit to employers having naked agreements of fixing wages of employees. Do I think it's going to result in real wages going up? No, I don't, because I think we got a very broad pool market, and I think the reality is the reason why they couldn't deal with these, I think Ed says, because maybe the enforcement under 90.1 is questionable. I think because most of the places where this is going to apply is going to be like in the grocery sector, where you're going to have big pools of workers where they're very substitutable because you don't need to have, specific special education or qualifications and so forth. So it's a very large pool. And I think it's going to be hard to establish that within that pool of workers, a specific set of employers has substantially lessened competition. I don't think that would be the case. I think if reality is over time, if the grocery stores had decided to bring their prices down and there were other job opportunities for those people to go elsewhere, they would have started leaving, and all of a sudden wages would go up. And that's when the market would satisfy itself. But since there's no value in those kind of naked agreements, I think makes sense to criminalize them. But I don't think it's going to have any big impacts, other than making us all feel good about it.
Before we move on, I just want to note in comparative context, the DOJ recently brought and lost a criminal wage fixing case. So this is an issue, I think, that is increasingly a relevant one on both sides of the border. So it's interesting to see how things are developing in Canada in that context. Anthony, back to you.
Thanks, Danny. Okay, so let's move to another controversial aspect of the substance, and that is the increase in administrative monetary penalties. Susan, if I can turn to you first on your thoughts about the AMPs.
Thank you, Anthony. So there was a general call, I would say. I don't think the government's off the mark responding to the call for increased penalties under the Act. The Budget Implementation Act actually does two things. It removes the maximum fine for cartel behavior, which was set at 25 million as a maximum fine. And in today's business context, let's face it, that's a cost of doing business for lots of businesses that are important in the Canadian economy. So to have giving judges the rein to administer fines in their discretion, that's probably long overdue, and I don't think that's controversial. I think what is going to be more controversial is increasing the maximum administrative monetary penalty for abuse of dominance, and also for drip pricing, by the way, which is an aspect of misleading advertising. And this is probably more controversial. It's not that the absolute size previously, $10 million for a first offense under abuse of dominance and 15 for subsequent ones for corporations. It's not that those limits were, again, too low for many businesses, but the very fact that these administrative monetary penalties, they are civil fines, if you will. When people struggle with how to explain what an AMP is, they just shortcut to, it's a fine. But it's a fine without criminal due process. It's a fine that is administered and meant to be administered civilly. That's why it's called an administrative monetary penalty. It's meant to deter wrongful behavior, not to punish it. And the courts have said and they administer them in other contexts too. They're not unique to the Competition Act, but they need to be set at a level that the courts won't view as punitive. Their constitutionality and lack of due process, criminal due process, requires that they not be rise to the level where they're seen as punitive. And these amendments say that the maximum limit for an AMP is the greater of either the previous limit, 10 million for a first offense, 15 for another, or three times the actual benefit derived from the abusive behavior, or where that can't be determined, then 3% of the worldwide revenues of the respondent. Now, I think you're getting into territory personally where one could allege that this is punitive, especially when it's 3 times the benefit. That's not punitive. That's just deterring and enforcing compliance. It's I would think arguable that these were arising to the level, and certainly, if I was advising a corporation that was being slammed for 3% of its worldwide revenues, which probably is going to impact more Canadian-based businesses, because multinationals, it's probably only their local affiliate who's actually responding to the charges. So that's another whole question. But 3 times worldwide revenues, that could quite likely be punitive, especially if it's hugely disproportionate with the benefit derived from the abusive behavior. And just the abusive behavior, it's civilly reviewable. It is not actually against the law to abuse a dominant position. It can be civilly reviewed, and then you can be told not to do it again, and they can administer this AMP to sort of back up. You should not do this again. But it's not wrong unless and until you're ordered to stop it, and you don't. If you breach an order from the tribunal not to do the abusive behavior, that's a criminal violation. But before then, it's legal behavior. And there's lots and lots written out there as to why these are normal business practices that just shouldn't be used in the hands of a dominant player. So there's all kinds of, I think, it'll be interesting to see how these play out. As I say, they are undoubtedly going to be passed into law. And the first time the government tries to impose an AMP of 3 times worldwide turnover, I think it'll be very interesting to see what the courts have to say about it.
Yeah, thanks. And Jason, your thoughts on either the lifting of the cap or on the AMPs?
Yeah, so I'll just say a couple of quick things. First, Kate McNeese and I, my partner, we wrote a paper to the industry committee, and one of the things I believe that needs changes of the act is, first of all, structural. Susan's exactly right. She said right down to it, which is the act doesn't make any of this conduct unlawful. So how you can have law, until the tribunal tells you otherwise. So how you can have lawful conduct, that then requires an administrative monitoring penalty is wrong. I believe that if they want AMPs, they ought to make this conduct first not lawful, and that so change the structure, change Part 8 structurally. But I also believe that the act needs real teeth, or it's just a cost of doing business. So I am in support of the idea of having greater penalties and consequences. I do find it odd, and we're going to get this in private enforcement as well, why we are so fixated on dominance and we don't care about agreements between competitors that have the exact same effect, the substantial lessening of competition. Why are we differentiating? Either we don't like anti-competitive acts and we want to say there should be penalties attributed to those conduct, or we shouldn't. Like, why are we doing? We're putting one set of conduct subject to potential administrative monetary penalties and not another. So I'll get into that. And finally, I do wonder if the language was a bit screwy here, because they do say specifically that it's the person's 3% of the quote person's annual worldwide gross revenues. And in my experience, if you have ABC Global Co. that's operating in Canada through ABC Canada Co., the contracts and the conduct is going to be by ABC Canada Co. And it's going to be, therefore, that's the person who's engaged in the practice of anti-competitive acts and abuse their dominant position. So it's going to be their global revenue. So if they wanted the group, they're not going to get it, I don't think, because that's not how this language was drafted. And maybe that was intentional, in which case, great, or it was a screw up, in which case, next time, consult.
I just wanted to jump in and say another aspect of these AMPs that troubles me is with what Jason was talking about, private parties bringing the cases. And I'm not a constitutional expert, but to my mind, private parties seeking the imposition of public fines it's a bit of a problem. I had I been consulted, would have said maybe the commissioner ought to have to intervene and the commissioner be the one to request an AMP. I find it very troubling that a competitor strategically motivated to bring the litigation is going to seek just, you're going to ding your competitor for 3% of their global turnover. That's a pretty big prize. It doesn't go to the private litigant. It doesn't help fund the litigation. So those who are perhaps most harmed by abuses of dominant behavior, the small startups that don't get a chance, they still have to fund the litigation without damages. So I might have gone more toward allowing the tribunal to impose damages that actually encourage the private litigation. But I find this public-private mix a bit troubling.
And we'll come back to the private rights of action later. But Ed, do you have thoughts on the lifting of the cap or the increase in the AMPs?
Yeah, just two quick things on the AMPs. I mean, one is I'm troubled by the idea that however defined, and I take Jason's point, but however defined that revenues are the kind of touchstone, even contingently, but the touchstone for determining what the fine ought to be. It seems to me if you want to zero in on the kind of social harms of an activity and the worldwide revenues of certainly some of the, a big platform would be completely out of whack with any kind of social harm. So I think the risks of kind of over deterrence, that people will be just too cautious to do something with small benefits, but potentially huge financial penalties is just problematic. The other thing I would just say very quickly, on Susan's, I think, well taken point about the potential, there will be constitutional challenges about this, to be sure, if this very high administrative monetary penalties are attempted to be imposed. But what this is going to do is just put further pressure on a distinction that makes no sense to me, which is, well, it's okay for an AMP to deter, it just can't punish. I don't even know how to start with that, because of course you punish in order to deter, it seems to me. And so in any event, so that I think it's unfortunate that we're going to get another round of back and forth over something, over a distinction that doesn't make a lot of sense to me.
And I would just add one last point I'd add is part of the paper I put in. I mean, I do worry about freezing, which Ed just said, freezing legitimate behavior, right? We want people to compete on the merits. It's often very fine line between competing on the merits and abusing a dominant position. It's not efficient for people to avoid competing. That's nothing we want to do. So I actually believe that there should also be an avenue where you can notify your conduct to get you out of, notify to the Bureau that you get you out of potential exposure for monetary penalty. This way, you have the specialist regulator who can take a look at it if they want, but at least you know when you're starting this behavior, whether it would be under abuse of dominance or if one day we have AMPs under competitive collaborations, you can notify it and then get yourself out of abuse and at least encourage companies to compete as strong as possible and not have to pull short of where they really need to be, which I don't think is efficient, but what they're creating here.
Jason, I think that's a great segue to really get to what do we mean by anti-competitive conduct? And I thought, Ed, maybe we could start you off on that topic and hear then from the rest of you.
Okay, and then we'll come back to private rights. I don't know if Susan wanted to expand more.
I missed that one. Sorry. Yes.
I was covering for you beautifully, Danny.
Sorry. And on private rights, Jason, what you also suggested. Sorry, skipped one of the questions in the order that. But
we are not. This is not in any way, shape, or form structured. Just to be clear, this is free.
Just
free flowing. Free flowing.
Sorry,
just like my slides. Anyways, we'll go. When we talk about private rights of action, let's set the stage. And I'm just going to use the term private action pretty broadly. So right now under the Act, we have kind of two types of private action, if you will. The first is private damage claims, and those can only be brought for violations of the criminal provisions of the Competition Act, or if a party fails to comply with a competition tribunal or court order that was issued under the Act. And so it's very limited. And that's where you have private rights of action, and you could actually have private damages. Separate from that, under the civil provisions of the Act, as I started off earlier by saying the Act is divided between civil and criminal. So under the civil provisions of the Act, a private party can apply to the competition tribunal for leave to bring certain enumerated actions or applications before the tribunal. Today, currently, it's refusals to deal, it's price maintenance, and it's exclusionary conduct, exclusive dealing, tied selling, and market restrictions. Now, the order that they can seek is the one that's provided for under the Act alone, which is typically just an order to stop behaving in the anti-competitive manner or requiring somebody to be supplied for refusal to deal. There are no monetary penalties that you're entitled to. Now, you could also bring under those sections, under Section 104, injunctive relief, and you could also have registered a consent agreement between the party who you say is acted anti-competitively, and that could be registered in front of the tribunal under 106.1, and it would have the effect of a court order. So the amendments are effectively designed to broaden this to now allow abuse of dominance to also be one of the other claims that you could bring in, and that will be also for 104, which I said is injunction, and also 106.1, which is consent agreements. Now, in my view, this is going to really is probably much to do about nothing. I think that what we're going to see is if you're a company looking to, or a person looking to bring a case, you're probably going to try to do this. You're going to try to bring an injunctive relief. If you get it, then you can try to negotiate a consent agreement for your own benefit. The AMP will be a reason why the potential for an AMP will be the reason why the dominant firm may do it, may agree to it, which was not existing under the other provisions I've said, so the refusal to deal and price maintenance and exclusive dealing. So that will be why. And if you don't get your injunction and therefore there's no incentive for the consent agreement, then probably they walk away, because this is an expensive, time-consuming process that you're now doing a public good. You're going to try to get an order that, and so everyone's going to want a free ride off of the party who's coming in and paying all the money to and taking all the time to bring a case. So it's going to be very difficult absent rights of monetary damage. I also touched upon the point that I still don't understand why they are only bringing private, expanding this for abuse of dominance and not 90.1. You could say, well, 90.1 is kind of like criminal, and they already have section 36, which allows you to bring a case for conspiracies, except that conspiracy does not include buy-side agreements. It doesn't include where there's ancillary restraints defense, so where it's a perfectly otherwise non-criminal agreement between competitors, but nevertheless substantially lessens competition. Why we don't have private right of access there, but we do in abuse of dominance, to my mind, it doesn't make a lot of sense. And then we already talked, Susan touched upon the whole point of, is it right that they should be able to also bring a case that there's an AMP? So, at the end of the day, you spend all this money and the crown benefits, the public benefits, but you've suffered harm and you don't actually get compensated for the harm suffered. So that's what I have to say on private rights of access.
I think just to follow up on one of your points there, Jason, and the fact that those most likely to be harmed by abusive behavior, how are they going to fund that litigation? Whenever I have clients coming to me asking, what can I do? I'm being abused. And the conversation stops as soon as I say, but you can't get damages. And they're like, well, then how do I pay for the uncertain litigation? Because litigation's inherently uncertain. So there's going to be, the government has said there will be a second round of consultations about another second round of amendments. It remains to be seen whether they're going to consult more broadly, have a public task force with hearings and a real conversation with broad range of Canadians, as they did prior to the 2009 amendments. I think whatever they do, hopefully they will run draft language by folks to avoid unintended consequences of their drafting. But in this second round, one of the things to my mind ought to be damages for private parties if they want to see private parties actually taking advantage of the statute.
Ed, any final thoughts?
Really nothing. I think Susan's last point is really critical. I think this might be another amendment that doesn't generate a lot of activity unless there's more of a carrot for private complainants.
Great, thanks. So so there's changes to private rights of action with regards to abuse of dominance, and there's also changes with respect to how we're defining anti-competitive act or anti-competitive conduct under Section 79. Ed, if you want to just outline exactly what the change is and whether you think this is good, bad, ugly.
Sure, I will do this. And again, not bad, could have been better. So abuse of dominance, and this goes back to Jason described this at the beginning. It requires a dominant firm, somebody with market power, to engage in a practice of anti-competitive acts that substantially lessen or prevent competition. So there's Section 78 of the Act sets out a list of examples of anti-competitive acts. The case law has looked at this list, as Jason said, and inferred that there's a requirement for an anti-competitive act that it has a harmful effect on a competitor, namely a predatory, exclusionary, or disciplinary effect on a competitor. The problem with this approach, this longstanding now approach, is that a negative effect on a competitor is neither a necessary nor a sufficient condition for a negative effect on competition, right? So it's not sufficient because harmful effects to competitors may not harm competition. In fact, harmful competitors may in fact reflect robust competition. It's not necessary because practices that help competitors, such as a practice that keeps prices high, may undermine competition while benefiting their competitors. So it's neither necessary nor sufficient. So I think the case law has been misguided on this, and it's created different kinds of problems. Okay, the Act addresses this problem, but doesn't do so in the most straightforward and logical way. To me, the most straightforward approach would be just to eliminate this definition of an anti-competitive act that has a harmful effect on a competitor, right? Just ignore that part of our case law. Instead, just define anti-competitive acts as being those that harm competition rather than harm competitors. But that's not what the amendment did. What the amendment did was kept the case law and indeed codified this case law requirement of a predatory, disciplinary exclusionary effect on a competitor. It kept that, but then added or an adverse effect on competition. I think that second move was a good one. I think, to allow that an anti-competitive act ought to have or could have a negative effect on competition was a positive development. But keeping in this effect this possibility that an anti-competitive act can also be defined by its negative effect on a competitor, I think is problematic. Okay, so then there's actually, and this is kind of in the weed, well, a little bit in the weeds already, but further into the weeds, there is an additional anti-competitive act, which I'll just quickly paraphrase, would include something like a selective response to a competitor that has the purpose of impeding the expansion of that competitor. Okay, well, this could include all kinds of really beneficial but robustly competitive acts, right? So if you have a multi-location retailer that has an entrant only in its location, lowers its prices only in that location to deal with the new retailer, that's competition. That's competition in action. But that could be presumably regarded as a discriminatory or selective response that is designed to impede the expansion of a rival, because competition is designed to impede expansions of a rival. Now, maybe it would not, maybe something like this, they define that out in the case law, but it's certainly on its face invited. So harm to competition, not harm to competitors, ought to be the point. Now, it is true that it is, even if one shows a practice of anti-competitive acts, that doesn't completely substantiate a finding of an abuse of dominance. You need also to show that there is a substantial lessening of competition. Okay, there's two elements, not just a practice of anti-competitive acts, but also an SLC or prevention. I still think there's still two problems with this, though. One is just kind of statutory incoherence. So you could have a practice of anti-competitive acts under our act, under the Competition Act, a practice of anti-competitive acts that doesn't in fact harm competition at all, right? In fact, it may in fact reflect competition. So I just think it's a bizarre use of language to describe something, to define something in the statute as an anti-competitive act that's actually pro-competitive. So I just think that that's intrinsically problematic. Secondly, I think that there's a danger by maintaining this focus on harms to competitors. I just worry that we're inviting a slippage in the application of the substantial lessening of competition test. That is, that there will be a danger that adjudicators at some point now or in the future, or that the Bureau and its enforcement priorities might start to blend harms to competitors with harms to competition. I think, the provisions invite that by defining an anti-competitive act this way. There's a purpose clause in the Competition Act that refers to basically, let's make sure that small and medium-sized enterprises have an opportunity to compete, so they could hang their hat on the harm to competitor kind of priority also on this Purpose Act at the beginning of the act. And then I think there's also just something in the zeitgeist right now. So even we're seeing these moves, blanket prohibitions on self-preferencing without necessarily a test for substantial lessenings of competition in the EU, for example. That, I think, is about protecting competitors and not competition, at least in the way that Canadian law has typically understood it. So I think all of these forces might conspire to put pressure on this provision to do something that I think would be unwelcome, which is finding abuses of dominance where there's been a harm to competitor, but not necessarily to competition. So I will stop there.
Thanks, Ed. And Susan, quickly, your thoughts on the broadening of the definition?
I think fixing the wrongs of the case law that had focused on harms to competitors was necessary, but as Ed says, they curiously kind of codified the problem with that language. And I think that if they actually are, if they want private actions for abuse, if they want the private sector also to enforce that, then these problems are going to be amplified. And I'm not necessarily against private enforcement of the abuse section, but we need to make sure that the framework of what is an abuse of dominance is robust. It's right, if they stick to their knitting and make sure that there's an actual harm to competition in the other section part of the provision, then we'll be fine. This is just an illustrative list, and you still have to prove that there actually is a negative impact, a significant negative impact on competition. But it's going to be all the more important once we do get private rights to the tribunal for this.
Yeah, great. And Jason, your thoughts?
Yeah, so look, I'll just say quickly, I'm absolutely against expanding anti-competitive acts to include exploitative abuses, and I don't believe they've done so here. What I wonder is whether the government, because they haven't told us what they were trying to achieve, whether they've screwed this up. Because if you look at Minister Champagne's letter to the commissioner, I believe it was on May 9th, about a number of areas, including maritime containers, it was all about how there's exploitative conduct going on, and well, guess what? And that letter referenced the amendments to the act. Guess what? You don't have a statute that a competition act that deals with exploitative abuses, and I wonder whether that was what they had, whether they thought that's what they were capturing, and I don't think they've done that here. So, and I don't think they should, because I don't think that we want to get the Bureau into a price regulator. But it is just interesting that we keep on hearing about high gas prices, and the Competition Act is supposed to address that. Well, that's not what our act does. So I just wanted to highlight that point, but not suggest an amendment to address it, to be clear, but just to highlight what I wonder if the government was doing what they thought they were doing.
Well, when you rush an act through outside the normal processes, as you would say, sometimes this happens. We're running short on time, so I wonder if we could have a lightning round. Mergers.
Yeah.
Jason, you've already opened up some criticism just now to the government. I wonder if you can tell us about mergers.
Yeah. So I think I am almost the most passionate about these changes, which are just terrible. And I'm saying that here as, again, there's views of my own, not my firm and necessarily clients, but these are really not well thought out. So first of all, first, as I highlighted or I identified before, now if a transaction is designed to avoid Part 9, which is the notification rules, then the substance of the transaction will be subject to those provisions being sections 114 to 123.1. So first of all, designed, what does that mean? Does it mean that you thought about it? Does it mean that it was part of the consideration? Does it have to be the preponderance of the consideration? At what point does it become designed? And I think that is a huge uncertainty. I mean, if they're thinking about all these tax strategies, and we say, oh, and by the way, one upside is that you're also going to avoid a notification filing, has it now been designed for that? I don't know. It was certainly a consideration. So I think that is wrong, and also it really opens the question on what this really means, because the act has a 1-year limitation period. So the Bureau could only challenge a transaction on substance 1 year after closing. So if they find out about it a year and a half later, their only ability at this point is to bring a case under 123.1, which would be for example, to potentially a $10,000 a day fine, and also seeking to break up the transaction. That's awfully big sledgehammer, particularly if the deal didn't have any issues. So maybe we'll see the Bureau investigating and then deciding that they've decided there's a substantial lessening of competition, and then they'll now not have to prove that. All they have to prove is that you designed your transaction to avoid Part 9. It's terrible. It's unnecessary. If people are able to structure around the Competition Act, fix your notification rules. Don't put in some amorphous idea that no one will really be able to determine whether or not you've, quote, designed. It happens, and in my experience, it's so rare that somebody is going to try to structure out of the Competition Act, because the tax issues, et cetera, are often far outweigh any benefit from avoiding the act itself. And the last thing, and very important one, this is really technical, but our act applies that where it's a shared transaction, the parties to the transaction is the person who's trying to acquire the shares and the company whose shares are to be acquired. So there's a provision that provides that where you're acquiring shares, you can alone start the waiting period. And the idea ultimately is that where you can't force the target, that you shouldn't be able to be not able to start a waiting period, because they should be agnostic, the notification rules on corporate structures and on transactions, the rules themselves, not the substance, but the rules. And so, the obvious places for where you have a hostile bid, but it's not the only place where that could apply. Like, for example, you have a 49-51 joint venture, and the one of the parties wants to the party who's one of the parties wants to sell their interest. The other party doesn't want to engage in that transaction. Now they have no way of forcing the other party along, because they can't. If it's the 49% party, he can't it can't tell the company you need to file. Or what if you have a public market transaction, a U.S. seller who's selling 25% of their voting shares? Now are we going to have global deals held up because you can't force the company to actually put in a filing? And maybe if it's a no-brainer, it's not a big deal. But if it's a difficult deal with the second request, a SIR we call it in Canada, which is very expensive, good luck trying to get the company to participate. And this is just nuts. And what's even more nuts is they did this as a Budget Implementation Act. Was this so urgent that they felt that there was so many filings being done, that the Bureau was so prejudiced that they had to do it like this? And if that was the case, isn't there other ways to do it, like expand the waiting period that the Bureau may have for these kind of filings, rather than just totally disrupting potential deals? And Canada's going to get embarrassed if there's a global deal and you can't get your deal done in Canada because of a notification problem that was broken. That was fine and became broken thanks to an amendment. That's all I have to say. Obviously quite passionate about this one.
All right. So I think we have run out of time. I'm afraid we had lots more to talk about, but obviously lots of controversial changes running from good to terrible and nuts for the last one, according to Jason. So thank you very much to our excellent panelists, Jason, Susan, Ed. I'll hand it back to you, Brian. So thank you very much.
Sure, thank you very much, Anthony, and thank you to all our panelists for a very informative and interesting discussion and observations. Very much appreciated. We thank all of you who attended today's session. As noted in the chat, we will make or share Jason's slide deck and the recording in the next few days to those who attended, and we have your email address. So again, thank you very much, everyone.
Thank you.